Hi everyone, and welcome to my channel where I talk about everything HR related and its intersection with the law under the Naija HR Chic Series. With me, I know I had posted about talking about this case before now, I think on Instagram and TikTok, and I may have gotten a few questions that I'm going to try and address in today's video. My name is Ijeoma, and if this is your first time, welcome to the community. And if you're already an existing subscriber, hey, gang, don't mind me. I'm trying to be as jivey and as alive as I need to be. It's been a long day at work, and I'm just saying, okay, I need to get this video because it's been a long time coming, okay? So, I'm going to address a few things in this video. I'm going to try and define a few things, who the claimant is, who the defendant, because I got a few of those questions from my very first video where I talked about Benedict Olusoji and Nigerian Army, a triple video, and you don't know that I was going to be able to talk for that long, but hey, we are here. And today's video is about Chigozie Esther and Covenant University, Nigeria. Yeah, it's Nigeria, and two others. So I'm going to try to talk through the claimant's case, what made her go to Nigeria and National Industrial Court of Nigeria, and then the defendant's case and what the court decision was about. I'm going to end with a few takeaways for HR professionals and what we can do better for our organizations. Okay? So the first thing I'm going to talk about is the claimant's case. I'm going to be looking away from the camera a few times to just read through my notes because I cannot cram everything. Okay? So the claimant claimed that the defendants, in this case Covenant University, were negligent in keeping their kitchen floor safe, resulting in a slip and fall accident. She fell down and then it resulted in burns for like a percentage of her body, and it involved hot oil, and that she had worked for them for over a year and was employed as a casual worker. She received some medical treatment from the defendant, but it wasn't enough as she had to pay for additional treatment from her pockets, out of pocket expenses. And now she's seeking compensation for pain, suffering, loss of enjoyment of life, and cost of medical bills. Now the defendant is saying that they weren't negligent in the handling of the safe working environment, and claim that the claimant was at fault for the accident because on that day in question she was not supposed to be frying fish, which is why when I talked about it in that teaser I was laughing, because it's not like it's a funny case per se, but it was a case of, oh, we did not ask you to do this, you went to do it on your own, so you are solely responsible for your accidents. So we are not negligent in the sense that we created a safe environment for you to work in. And then they also argued that she did not follow proper safety procedures and then caused the spill herself. And then they said that she wasn't entitled to sue them directly because they had filed a claim under the Employees Compensation Act. One of these days I need to take out time to dissect that act because it's becoming a lot of issues in the National Industrial Court decisions, some of the decisions I've read. And then finally, they challenged the admissibility of some of that evidence. And don't worry your pretty head, I'm not going to talk about the Evidence Act, even though I'm a lawyer, right? As amended 2023, and how it included some photographs and a medical report. So the court decided that, I'm going to quickly read through the decision, that the claimants, number one, could sue the defendants and did not need to go through the Employee Compensation Act first. Number two, they said they were going to accept the photographs that showed the burns and the medical report, even though it wasn't certified. I will get into that this way in a later video to explain when certain types of evidence can be presented, whether documentary or photographic, and the procedure that they have to take, who has to produce this evidence and all what's not. And that because the National Industrial Court Act only allows more flexibility in admitting evidence, and that finally, while the court has not yet decided on the final outcome of the case, whether the claimant will be awarded compensation and how much, it will consider all the evidence that has been tendered and presented before it would. So this is just like a summary of what happened in the case. So she's been working with Covenant University for a year, goes into fry fish that fateful morning, and then there's a slip and fall. which happens to every one of us. You must have been cooking in your house and then you fall down and then there's an accident. The only difference is there are different levels to how do you prove that there was an accident in the first place. And I'm just going to quickly read through what needs to be proven before you can claim for negligence. And then the first thing I'm going to read through, don't mind me. If you say you are suing, in this case, Chigozie is suing Covenant University for so and so thing, you have to be able to prove three things in an action for negligence. Number one, you have to prove that the defendant, in this case your employer, owes you a duty of care to make sure that a safe working environment is provided for you. Number two, that they breached this duty, meaning they did not provide this safe working environment for you. And then thirdly, you suffered damages as a result of this. So she is saying because the environment was not safe enough for her to work, which was the kitchen, it led to her slipping and falling, and that she suffered permanent scarring, pain, suffering due to it. Even though she was offered treatment, it wasn't enough, and she had to use her own funds to make sure she got additional treatment. And that's why she was asking for some things. And I will just quickly read through what she was asking for. So she was asking for general damages for negligence and pain and suffering in the sum of 15 million naira. She was asking for compensation for loss of life, loss of enjoyment of life amenities, 5 million, medical expenses and other costs, 2 million, interest on the sums are going to be awarded for the date of judgment until it is finally paid, and then the cost of litigation was 500,000, which involved filing of process and all that. So the total amount that was going to be given to this claimant was 22 million naira 500,000 as specified. Now, when you look at this, there's a lot of questions that arise. You're thinking to yourself, okay, why are we making such a big deal about this? Somebody fell down. Why is she coming to do this, that? And then part of what the claimants were arguing, part of what the defendants were arguing was to say that, oh, she was not a proper employee. So that's why she could not go directly. If she was a proper employee, she could sue them directly, but because she was a casual worker, she had to. There was a lot of back and forth on this part, and I know that it might not make sense to you who is not a lawyer, but they were saying, oh, she's not a permanent employee, she was just a casual worker, and that they denied the negligence because she did not follow procedure, that they had a process, like a workflow process for how to fry using hot oil, and that she did not do that, and that she didn't clear her surroundings. So it was like, you made this environment unsafe for yourself. So you come back to say you had an accident due to us not providing a safe working environment is not tenable in court. And then they claim to have fulfilled their responsibility by covering medical bills. She said she had to get additional treatment. So there was a bit of back and forth. So the first one of the issues that arose was, okay, number one, can she sue directly, or does she have to go through the Employee Compensation Act? And because I said I don't want to bore you with too much legalese on this channel, I will not talk too much about what you need to do to go and sue an employer through the Employee Compensation Act. Come and meet me in person. Let me break it down for you. And then photographs that were presented in this trial and a non-certified medical report, were they admissible? Yes, the National Industrial Court has been known to be flexible in admission of evidence. But then the question is, were they really supposed to admit it, especially when it was not certified? And then, was the claimant able to establish that, yes, like what I explained in the beginning, there was a case of negligence being brought against the defendants, and then that would result to the damages being asked for. And what the court was saying is, yes, at first as we're going to be very flexible, they found the photographs and the medical reports admissible, even though they were not certified, which was a little bit strange. And at the end of the day, what happened next was, my question is, how far can the courts go? Even if I know that, okay, there are a few things that they are free to do as a National Industrial Court, but how far do you have to go to prove that, okay, there is a burden of proof that has been admitted by this claimant. But because the court is also going to say you are presenting different types of evidence and I have to be fair to both parties, I'm going to read out something that was relied on in this particular case. So, judge said, before I draw curtain on this judgment, I need to reiterate the imperative of the claimant in an action for damages in negligence to be able to prove that the particulars of negligence in this case alleged against the defendant. So if you are saying that, oh, this negligence was caused by the defendant, you need to be able to prove it. And that was not done in this case. So negligence is a question of facts, not law. And facts are proven by oral or documentary or read or a combination of all of this. And then the court went ahead to cite section 131 of the Evidence Act, and then a few cases, Ofwani and Emodi, very interesting case, I should get into that soon, and how this was going to come into play in their decision. And then finally, in this particular case, the claimant neither pleaded nor proved the particulars. So in essence, she had said everything she needed to say, but it was found out by Justice Peters that she was not able to prove it. And this was fatal to the success of her case. So in essence, she couldn't prove that negligence happened, even though there were photographs to the letter to show that, okay, this accident did happen and all that. But because she was not able to prove it, and it was a case of facts, if you're telling me that this person breached the duty of care, you need to be able to prove it to me for you to be asking for this, amount of money and all. But that was not done. And then finally, for the avoidance of doubt, they had to dismiss the case of the claimants in its entirety. And yeah, I can imagine what you feel right now, because they're thinking, oh, boo-hoo, poor her, lawyers are not fair and all that. But then again, what are the key takeaways for HR professionals? Because I just don't want to look like I'm talking about a case review and not giving you something to take home. And the first thing is, number one, employers, whether it is a restaurant or Covenant University who was sued in this case, or a law firm, you have a duty to your employees to provide a safe work environment. I cannot stress how important this is. It will shock you the kind of things that take employers to the cleaners, where people do things that at times they are wondering, oh, was it such a big deal? Yes, it's a big deal, because people have been known to slip and fall and lose their lives in the process. And then how much more can you pay for a life when you could have just prevented that from happening? Second thing is knowing that the burden of proof lies with the employee to demonstrate. So if you are an employee and they're saying, oh, a safe work environment was not provided to you, this case should be a cautionary tale to say it's one thing to run to the courts for justice, another thing to be able to prove your case without any doubts, reasonable doubts. And then specifying the details is very crucial for a successful case. It's one thing to say, oh, they did not provide a safe work environment for me, and that is why in this case she slipped and fell. But you need to be able to say, over time there have been documented reports to say, we have brought this to the attention of management, we have said this, we have said that, and nothing has been done. That way it now becomes a pattern. It's not just a one-off like this was seen in this particular case, because nobody was able to prove that this had happened before and something had been done. And then employees was able to provide evidence to link injury to the employer's action. I talked about that. So what this means is, you HR professionals, number one, call to action: review your workplace safety procedures, protocols, and ensure compliance with relevant regulations. I cannot stress it enough. I know that we had a workplace first aid training in my office recently, and it reiterated the need for safety measures to be put in place in offices. You do not want to know and believe what people are capable of, doing. And then if you have someone who is able to offer first aid, it can save a life right before they get to the hospital, depending on the nature of that person's ailment or illness. And then, secondly, please, because this is something that most organizations don't have, you need to have a clear communication channels where people can report safety concerns. Yes, HR can be bogged down with everything, but if you don't have a safety officer or a facility officer who takes care of safety related things, make sure that hazard signs are placed in strategic places. Let's say you are occupying a service office space, for instance, you need to also educate your HR officer if you don't have a safety officer or who takes care of these things, because these channels need to be open for employees to be feeling that they can report safety concerns, not necessarily about slipping and falling, but their surroundings. And then advise management. You have to document employee safety trainings and incident reports. I cannot stress this enough. Where I hear things like, oh, somebody reported that something was stolen, was there an incident report? You hear no. For the life of me, I struggle to understand why we make mistakes like that. Only because I cannot stress how important this is. But these are three things that I feel that we've taken away from this particular case review. I thought I was going to break this down into two-part series, but I think I've been able to do justice in one particular video. So I think I'm going to just quickly go through and see if there's anything else that we need to add. But hey, if you have any episode, any issues, any topics that you feel that we haven't addressed, hell, any case that you think, okay, can we have you review a case that borders on termination, wrongful termination, apart from the one that I have treated, which is Benedict Olusoji's case, do hit me up. I can be found everywhere. I'm on TikTok, I'm on Threads, I'm on LinkedIn, I'm on Twitter, and I am on Instagram. You can also shoot me an email at ijeomaucheibe@gmail.com, and I will be sure to respond with whatever you need. It might be slightly delayed, but I promise you it won't be exit to business days. Let me know what you thought about today's video, and if you haven't subscribed by this time in the video, hit the subscribe button in the description box down below. Don't forget to like, don't forget to share, don't forget to comment. Let's keep the conversations going. Till I talk to you again very, very soon. Take good care of yourself, guys. Bye. Hi everyone, so my name is Ijeoma and welcome to my channel where I talk about everything HR and its intersection with the law under the Naija HR Chic Series. So in the second case that I'm going to be looking at, it's Chigozie Esther and Covenant University and two others, which bordered on contributory negligence and how you can prove negligence at a place of work. She apparently was a casual worker who is suing the university and two others for loss of enjoyment of life, pains, and bonds that she sustained during the course of working with the university at the time. And I will try, without involving too much legalese, to get into the basics. What do you need to do to prove negligence, and how can you help your organization remain foolproof? Because what I am trying to do with this case reviews is just to say these people matter, employees matter, employers matter, and then when we have disputes that end up in National Industrial Court of Nigeria, for instance, what are the lessons that we can learn? What are the pain points of these issues that led to the point where they felt the best way to get these things resolved was through competent court of jurisdiction? And then most importantly, how can you protect your organization from having this happen to them? Because every other day you see people going to court for some very, very ridiculous things that you can feel and tell that is avoidable, but people don't listen. But we can only keep pushing and hope that one day employers sit up and do the needful for employees in Nigeria and across the world. But this is the second case that I'm going to be treating on the case review series, and it's a very exciting one. I can't wait to get to it. I hope it's not going to be broken down into too many chapters like I did for the first case. I hope to just cover everything in 10 minutes, but if it does expand, I will let us know if it's going to be a two-part series. But keep it locked. If you haven't subscribed to my channel,